everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney Sheela Murthy to discuss the latest updates and about the H-1B registration process. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice and it is general in nature. It is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. You all know very well about Miss Murthy. She's the founder and president of Murthy Law Firm and a Harvard Law School graduate. Also, she is the one behind the famous website murthy.com. Before getting into the session, I would like Miss Murthy to just give a brief introduction and then latest update, and then we'll take it from there.
Sounds good. Hi, Ranjit. Hello, everybody. It's fantastic to be here today and to continue to support you all, answer your many questions, queries, and confusion that you may be suffering with the U.S. immigration law. As Ranjit just told you, we started the Murthy Law Firm over 26 years ago. It is, of course, the website, murthy.com, has so much free information. So if you have additional doubts or clarifications, you can sign up for the free Murthy Bulletin, the free chat, the free forum. There's an online discussion with over 150,000 people, and you're welcome to sign up for all those free services. So we would be honored to continue to help you. And I know last time Ranjit said, talk about your book. There's my book, Being Sheela, that you are welcome to purchase. Actually, it's by a free with a donation if you want to hear about immigration stories on immigrants and their lives. So you're welcome to continue to learn and empower yourself with knowledge and information as well. So let's open it up, Ranjit. I understand there are callers already impatiently waiting for clarification.
Yeah. We have a caller, Swapna. Let's take the call and we can take it from there. Hi, Swapna. Welcome to the show. Please go ahead and ask your question.
Thank you, Ranjit. Thank you, ma'am, for taking my call. Basically, we applied for 485 because the dates opened up in October. 29th of October, they received my application. And my husband has EB2 and EB3, both the approvals. So EB3 was a straight case where we don't need a downgrade, but EB2 was a downgrade. So we went for a straight case. And then I got a rejection notice on February 16th telling that your dates are not immediately available. Your priority date is not available, and they rejected rejected my case. I mean, like I think with your experience, you would have dealt with this kind of cases, right? Is it a big issue, small issue, and how can I resolve it?
Okay, very good question, Swapna. I'm so sorry that you even have to deal with this situation. It is quite common for the USCIS mailroom to get confused sometimes and reject cases that should not be rejected. So you can either double envelope it, send it back, saying USCIS error to be accepted by mailroom, not to be opened in mailroom for service center director. If you're a lawyer or companies connected with the American Immigration Lawyers Association, you can certainly go through the ALA liaison, but there is a system and a process for improper rejections, because the important thing is you need to have attached, or your lawyer or your employer should have sent the EB3 I-140 approval notice with the 485 filing. If by mistake they send the wrong I-140 notice, then the USCIS may not have made an error. It may not be a USCIS error. So it's important to double check, make sure that it was not an error from your side, the employer side, or the attorney side, or the HR from the company side. But rather, if it was a USCIS error, then you absolutely can bring it to their attention, ask them to accept it, and they will accept it, double envelope it, send it in, talk to them. You can call them, you can talk to the customer service. You can actually go through ALA liaison if the attorney or law firm is a member of the American Immigration Lawyers Association as well. But we do this all the time, and we are successful in having them take the case and the submission. We did this many cases back in 2007, because when there are thousands of cases, human error is likely to occur, Swapna.
We sent both EB2 and EB3. They scanned EB3 also, but they checked the EB2. They kept EB2 of Prasad into my file when they got the return file. The attorney received the return mail, right? The rejected mail. he saw that EB3 or EB2 of Prasad was attached to his file and EB3 was attached to my file, but he is the prior applicant. He is the main applicant.
Okay, but why would any normal person who understands immigration law send an EB2 and an EB3 case? It doesn't even make any sense.
No, when we put the supporting documents, he put both the documents, both the papers.
Why would you put the second document? Why would you even put it? You don't need it. If whoever is the principal, that's the only one, Sapna, that you would put.
Okay.
So this is how sometimes we cause our own problems. I remember as a child, my father would always say, Sheela, you can be your best friend or your worst enemy. And I always say it's so important, Sapna, they're first of all getting thousands of cases. They're confused, they're overworked. And now we have to make their life as simple and straightforward as possible. You show them your status, your H1 or H4 status, you show them your proof, but your I-140 petition attachment is a 100% not only not required, it will definitely confuse them. So this is something that just adds complications that you don't need. And I don't know if the lawyer did it or the company person did it, but it really shouldn't be done at all.
Okay. If we, like, my name is Swapna, and do you think you can handle my case?
We should be able to handle it. I'd like to look, as I said, we obviously, as Ranjit said up front at the beginning, we cannot give by law case specific advice on exactly, because I'd like to see the documents, schedule a consultation. Let's look at it. Let's make sure. Let's see how we can try to challenge and bring it back to their attention and try to accept it. Your company lawyer already tried and was not successful, Swapna?
We did not try it. We just got the papers back.
I see. Yeah. Okay. Yeah, it sounds like something that we certainly could help with and take, but you just want to be 100% sure. So why don't you just schedule it with an appointment and send the documents to us for review?
Okay, perfect. Thanks a lot.
It'd be an honor and a pleasure to continue to help you, Swapna. I'm so sorry you're dealing with this.
Sure. Thank you.
Thank you.
Yeah, we have another caller, Vinod from Maryland. Let's take the call. Hi, Vinod. Welcome to the show. Please go ahead and ask your question.
Hi, good afternoon. So recently, I have gotten approval to operate an LLC business in Maryland. So I did register the company with my residential apartment. Now I'm planning to sponsor some of my employees to the H1B. So I heard that we need to have a commercial space to file an H1B. So all my consultants are they work remote. They work for other clients. So I did lease a financial, a commercial space most recently, but my company has been registered in the address where I am at right now. So my question is, should I change the address of the company, or what would be the best idea, ma'am?
Okay, first of all, I wasn't clear. So just to confirm, Vinod, you are not, you are a permanent resident or US citizen. So it's not about your immigration case. You're just asking about sponsoring H1Bs because you're a permanent resident or citizen, correct?
Mm-hmm.
Okay, so it's true that in general, the USCIS does sometimes, as you know, the FDNS, the Fraud Detection and National Security, and the Immigration and Customs Enforcement do end up investigating and coming into the company site or to investigate whether there's a true bona fide job offer. So they may knock on the door, they may come into the premises. Sometimes at home, they'll say, how many people are allowed in this to work in this location, etc. So if you've taken a commercial space, when you file your H1 petitions, you need to file it with that address of your new business. And sometimes they will come in and ask to go check out and see how much space, how many rooms, how many people can sit and work from that space. If you are claiming that half a dozen people are going to be working as your H1B employees in that space. Now, if you say you have end clients locations that people will be working, then obviously we've seen that the USCIS takes that into account as well in determining, because as you know, the USCIS has generally been not very favorable towards third-party consulting companies and people working off-site. etc. But we're hoping that the Biden administration will change a lot of those policies and rules. So in short, just to summarize, it's obviously wiser, Vinod, for you to use the company address or the business address so that if the government, the ICE agent, the Immigration and Customs Enforcement, or the FDNS agent comes to your office premises, that they will actually be able to see who all are working there and investigate rather than knock on the door in your house and everybody in your family kind of getting really upset about the whole thing.
Okay.
Thanks for the call. We have another caller. Let's take the call. Hi, welcome to the show. Please go ahead and ask your question.
Hello.
Hi, Sandhya. Yes, Sandhya, please
hi.
go ahead and ask your question.
Yeah. Hi, madam. This is Sandhya calling from New York. Actually, my EB3, my I-140 filing date was September 2018. So last year we had spillover, right? So up to 2015 it came. So this year can we hope? Is there any chance of moving? That is one question. And one more question is, my daughter is 15 years old. So this year Biden new act, Citizenship Act. So they mentioned age out, right? So what is our hope about this one? Thank you, madam.
Thank you, Sandhya. Thank you so much for your call and for having the concern. So regarding the movement of priority dates, Sandhya, you know that nobody in the world is able to obviously give you 100% guarantee how it'll move, because as you know, it's based on demand and supply, movement of worldwide usage of numbers, based on what the US Department of State has already informed us, as well as the presidential proclamations which shut down the immigrant visa numbers, with no family-based cases coming from consular posts abroad. We do expect an unused, a big spillover number from the family-based into the employment-based category this year. So it's possible the numbers will move because they were supposed to move quite a bit. But I know that the USCIS was overwhelmed last year in October when they moved so much, and it was too much for them to process, and they're still trying to catch up on all those cases. Like the last time we had something similar was back in 2007. So this is something nobody in the world can give you 100% answer, because it depends on how much it's being used each month, how many visas are being unused, and how much will be put back in the pool. The second part of your question was about your child, the daughter who's 15 years old, who's going to be aging out. As you correctly pointed out, the Citizenship Act of 2021 issued by President Joe Biden on the first day in office, and that was introduced in both houses last week, in the US House of Representatives and the US Senate. Really, the goal is to freeze the age of the child as of the date of the parents filing the I-140 petition. I mean, so they're looking at children not having to panic or worry about aging out, because they're looking at a completely different formula of how to look at aging out to help children. There are several other provisions in that, including the visa numbers being used, as we talked about last time, per family as opposed to per person. So that will double or triple the number of unused immigrant visas available, which could also help to move the priority dates very much. Plus, if they're planning to eliminate the per country quota limit, Indians will not be as badly and adversely affected as under the current system. So the bottom line is, do we know if that bill will become law or not? It depends, because there's enough support from both Republicans and Democrats to approve vast portions of the bill. And so there's a good chance that some of it, at least hopefully, should get passed. The risk, of course, is whether because of partisan bickering and infighting and not wanting the Democrats to get success in immigration, the Republicans will put hurdles and vice versa, whether that could be a reason ultimately for certain portions not to get passed. But we're hoping that some of these sections regarding aging out, regarding elimination of per country quota limits, which both the Republicans and the Democrats, both parties are in agreement with, hopefully will get passed. So that's some watered down provision. And Biden has made it very clear that he would be willing to support it piecemeal if it cannot be accepted in its entirety. So stay put, be patient, and let's hope it actually works out. Sandhya.
We have a caller, Krish from Maryland. Let's take the call. Hi, Krish. Welcome to the show. Please go ahead and ask your question.
Hi, thank you so much for giving me this opportunity. This is Krish here from Maryland. I just have a quick question for Mrs. Sheela Murthy. So, is this session only for the H1B questions? I have one H4 EAD related question. Is it appropriate to ask in this group, or should I wait?
Yes, go ahead, please.
Okay. So this is regarding the H4 EAD. Hello, Ms. Murthy. I just would like to know, what are the ways and what are the scenario in that case if a wife is a healthcare worker in IT industry, as well as the EAD is going to expire soon. Is there any way that we could request as an expedite to the USCIS?
Yes, Chris, we have seen these all the time. We're doing expedite requests based for physicians or based in the healthcare industry, explain the pivotal role the person is playing and requested. There's no guarantee, Chris, that the USCIS will grant it, but especially for doctors who say they're working with COVID patients or other situations, because they have made an exception, as you know, even from the non-immigrant visa ban, the exception was for doctors who are working in the healthcare industry or people in the healthcare or food supply chain industry. So point out, you can even make the argument that, look, even in the presidential proclamations where there was a complete ban on bringing people in, they made an exception for people who are working in the healthcare industry. And since I am working, she would have to present it and ask for it as an expedite, either herself or through a law firm. Could be Murthy Law Firm or any other law firm, your company lawyer or whoever filed the H1 and H4 for you all, Chris. Check with them if they are willing and able to file and request the expedite request. Because just earlier today, I did a consultation with a medical doctor who actually was hiring us just to do this expedite request for the case, because I think in that case, the EAD, H4 EAD was expiring within 3 or 4 weeks. So there is not much time left because it's already been pending for quite a few months at this point.
I see. Yeah, because my employer haven't filed yet for the H1B, H4 and H4 EAD. They are going to do that before end of this week, and my current visa will valid for H1, H4 and H4 EAD till July 2021. And so basically, wife is losing the license, plus I have a strong evidence that my daughter is autism kid, and a couple of, the strong evidence that I have. So, like, let's say if I need to go through only Murthy, like, what is the best way to reach out to you guys?
Just go through law@murthy.com or just go to murthy.com contact, either call or email, and just say that I would like you guys to take this case or work on this. So you can either schedule an appointment, sort of what we're doing, but we'll look at all the documents in greater detail, ensure that it's okay. But if the company lawyer is filing the H1B and H4 with H4 EAD, you should go ahead, file it, get the receipt notice. And once it's filed, you still have a few months. It's only March, April, May, June, July. So you have 4 months. It's very tight for H4. But once you file it and get the receipt notice, that's when you contact USCIS, or even when you're filing the original case, the employer and the company can actually explain that we are requesting the H4 EAD and the H4 to be approved by bringing it to their attention as humanitarian circumstances, healthcare industry, and humanitarian circumstances because of the child having a medical condition.
Yep, I think that answered the question. So, yeah, Ms. Murthy, I believe there was a latest update on OPT. Could you please brief about it, and then we can talk a little bit about H1B registration?
Sure. So the USCIS issued a clarification just a couple of days ago about the F1 flexibilities being afforded to certain F1 optional practical training candidates. Before this new flexible rule under the Biden administration, the previous rule that was in place for years and years under the regulations required that the student has to apply for F1 OPT within 2 months, 60 days of the graduation date. And the USCIS has to approve it in order for the person to get the full 12 months. It made sense if the USCIS was making a decision within 2 months. and you applied 2 months before graduation. Now with USCIS taking so many months, even just to open the file, issue the receipt notice, etc., many students were getting a much shorter abridged version of the F1 12 months optional practical training. So the Biden administration has issued a clarification providing flexibility that they will consider the start of the 14 months and the start of the 12 months from the day that the USCIS, from the day that the person applies and the USCIS receipt notice is issued, so that the person can actually hopefully get the entire 12 months of F1 OPT instead of a much shorter version of the F1 OPT. That's the gist of what they're trying to do to encourage people from filing and in time. And also the rule is effective from October 1st of 2020 through May of 2021. And so you really, if your file was, and the second issue that they're giving flexibility is if your petition was rejected, because a lot of students don't understand, they forget to sign the form or put the wrong check. If the entire package is rejected and returned back by the USCIS to you as the F1 OPT applicant, you can send it back to them as long as the rejection occurred again between October 1st, 2020 and May 2021. You would send it back to the USCIS, pointing out that under the new policy of providing greater flexibility to F1 OPT students, please consider this as a timely filed application, because they are considering it as a timely filed based on USCIS error. That's the argument you have to make, because that's what they have said, USCIS error in rejecting this improperly as being outside of the 60-day window from the day that you graduated and should have sent in your F1 OPT application. So it's a very interesting turn. This kind of flexibility we have almost never seen for years, not under the Obama administration, maybe possibly under the Clinton administration. We saw some wonderful benefits that were helpful, that treated, that, looked at this as a nation of immigrants, where we need to honor and recognize the contributions of immigrants. But certainly in the last 4 years, it's really been very, very stressful, because the rules were either changed or completely ignored in order to make it difficult, if not impossible, for people to actually get what they're supposed to get, like an H4 EAD extension or a 485 EAD card, which was, all of them are taking months and months and months. Good luck. I hope it works out for whoever is applying.
Yeah, hope so. We have a caller. Hi. Hi, Sandeep. Welcome to the show. Please go ahead and ask your question.
Thank you, ma'am, for taking the call. My name is Sandeep. I had a recent denial of H-1B. But what we did, what the lawyers did prior to that denial and RFE process, was apply for my H4 and EAD based on my wife's I-140. The receipt is from November 13th, but it's, looking at the processing times, it's taking a long time. What I did in the meantime was go to India, get my H4 stamped, and then I came back to the U.S. What are my options now? Because I'm not sure if the previous EAD and H4 case are still going to be valid. And, if so, what are the chances, or what is it that I could be doing right now?
Oh, so you're right. Because it was a change of status application that was pending from H1B to H4, because it was filed prior to your prior I-94 card expiring, Sandeep, a change of status is deemed abandoned upon departure from the United States. So that H4 change of status application is deemed abandoned. You could try to salvage the H4 EAD by trying to send a copy of the H4, your I-94 card, and that the fact that you're in H4 status, to the USCIS with the pending EAD receipt notice. Try to merge the two, interfile it as we call it, to see if there's any chance or any way they would approve the EAD for you. Otherwise, the cleaner and proper way really would be, because that application should have been automatically, it's deemed abandoned upon departure from the United States. You don't want to wait 13 months to find out that you got a denial because it was deemed abandoned when you traveled out of the country and got the visa and came back. So you are probably better off applying for the H4 EAD based on your new H4 status, to see if you could try to get that faster rather than waiting to get the denial, because that case, the prior case, cannot be approved, because as soon as you departed the United States, you pretty much said that that case is deemed abandoned by law, Sandeep. So I hope your company lawyer, you discussed this with whoever filed your H-4 as well, and they discussed it with them. And what did they tell you, Sandeep?
Yeah,
Good.
So we have another caller, Ramu. Hi, Ramu. Welcome to the show. Please go ahead and ask your question.
Hello, good afternoon, Ms. Murthy. So, my call is also a little similar to the previous caller. My wife H4EAD is expiring this July 1st, and we filed the H4 on September 2020, and it's due to the and the EAD we filed on Jan 2021, Jan 4th, 2021. But at the time when we filed the EAD, the H4 was still pending. It's adjustment of status. We went to India and got it stamped now. So we still have some 4 months time. So and I'm still waiting for the EAD receipt. So what do you advise? So do you advise or how to notify USCIS that we already have a H4 with a different I-94?
So this is a completely different situation, right, Ramu, than what we just found. It was similar but different, because in that case, it was a change of status from H1 to H4. You said your wife was already on H4 before. This was an extension of H4 status with the H4 EAD, correct? So, yeah, I'm not hearing you. So if it is an H4 extension, then that is not deemed abandoned upon departure from the United States. So that H4 extension can continue, and the H4 EAD can continue, because it's not a change of status, but an extension of status, Ramu. So you could then send the USCIS, attach a copy of the law, attach a copy of the regulation, tell them that this case cannot and should not be considered as an abandoned case, that it should continue, that H4 application can continue, and the H4 EAD should be expedited because we are already on H4 status at this time. Please approve the H4 EAD, since the H4 change of status has been approved by the Department of Homeland Security at the time of re-entering with the CBP, instead of issuing the I-94 card. So even though it sounds similar to the prior situation, I think that's what I tell people every single time. Even a case that sounds very similar sometimes has nuances and differences that can make a world of difference in the answer, or in the guidance, or in how we have to strategize how to move forward, or be strategic in processing the case, or thinking of options or solutions. So I hope this was helpful for you. Thank you.
Yep. Thanks, Ms. Murthy. Thanks. We are towards the end of the show. Thanks again for your time. Thanks everyone for the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 1 p.m. EST to watch the special immigration show. Again, it's every Tuesday, 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thank you.